Mr. Williams, do you have any other announcements?
Yes, as far as position 1 is concerned, I did receive a message from Clerk Robeson regarding that they would like to be heard. So it is
it's already a consent. There is no be heard.
Right.
So, folks in Sealy, come on, because I'm going to tell you what we're going to do.
Right. And I explained that to them, but it was told.
There is no rehearing position 1. So before I talk to you, I want you to wrap that around your head. All right, so now I need you to unmute. And then I need you to raise your right hand so I can talk to you. All right, you too, Mr. Sealy, unmute. Raise your right hand for me. You swear or affirm to tell the truth under penalty and perjury of the law?
Yes.
Yes.
All right, great. So what's the problem? The only issue is the date. And it's not like we didn't know when you came in. So what's the problem? Who needs to go first?
The initial agreement.
Yeah, what's the problem, Mr. Sealy? I don't want to assume that it was you, but you did ask for the hearing to have it changed. So what do you want to do?
I just wanted the date change, and I wanted to move out to be the week of the 18th.
The courtroom session begins as the judge calls the next case and asks if there are any announcements. Mr. Williams informs the court that there was a message from the clerk regarding position 1, and the parties would like to be heard. However, the judge quickly clarifies that the matter is already a consent agreement and technically does not require another hearing. Despite that, the judge decides to address the situation directly and asks the involved parties to unmute and raise their right hands to confirm they will speak truthfully under oath.
Then, Kate, make the move out the 18th, because that would be greater than 7 days in and of itself.
The writ of possession has been expired, and I just wanted to let them know that filing the writ of possession, knowing that we needed to correct the consent agreement, that was on him. But for the law,
have you been evicted, Mr. Sealy?
Say it again.
Have you been evicted?
No.
Okay. That's not even really relevant at this point. Listen, your agreement says this. Tenant agrees to vacate property on January 8th, 2025, which would have been 2026, at 11:59 p.m. The landlord shall be entitled to a writ of possession on January 8th. It's supposed to be 2026. The landlord is entitled to a money judgment of $5,000. So this wasn't a pay and stay. So it wasn't a situation where you were saying, hey, I'm going to pay this money and otherwise I get to stay and the date's off. So I don't, tell me something else.
I mean, I wanted to correct everything, but like I said, when it came to the writ of possession, he filed the writ of possession knowing that we needed to correct the consent agreement.
Okay, that's okay, because I knew what the dates were.
After both parties swear to tell the truth, the judge gets straight to the point and asks what the actual problem is. The tenant, Mr. Sealy, explains that the only issue is the date in the agreement. He says he requested a change because he wanted the move-out date to be the week of the 18th. The judge immediately responds that such a change cannot be allowed because it would extend the timeline beyond what was originally agreed upon. The judge emphasizes that the writ of possession has already expired and the agreement clearly stated when the tenant was supposed to leave the property.
We knew what the real dates were.
Correct.
Because it's my order. So I'm happy to change those. And I'm sure the writ that was held up, which I see that it was held, but it can be reissued because it wasn't a matter of that he was wrong. It just was a scrivener's error. So we'll make that correction on the order. That's why we were requiring you to re-sign. I can try to go on here and try to do it myself. But again, because it was a consent, we would just need it to be updated. This is your request. So right. I don't know why you're not cooperating.
I mean, I am cooperating. I'm just letting them know that the consent agreement needed to be changed, and with the consent agreement being changed, it would come with new dates as far as moving out.
False. So if you either gonna sign or I'm gonna do it unilaterally, what you gonna do?
Say it again.
You either gonna update it yourself based upon the motion that you requested, or I'll do it myself. But we can't change the dates.
So when is the writ of possession authorized?
Technically supposed to be authorized any day now because you were supposed to be out over a month ago. You knew that. That's why you filed the motion.
Right. So all I wanted to do was cancel out the expired writ of possession.
Oh, well, brother, it's not being executed at the moment, but I'm going to make this change. And if since you won't go ahead and make the change based on an agreement that was already had with those dates, I'll do it myself. Because you don't seem to want to do it, even though you've entered into the motion or you made the motion.
No, I mean I'm definitely for the motion. I'm just letting you know that the dates have expired.
Okay. I know the dates have expired, man.
And that's just giving me the time to leave because I didn't have.
You've had more than enough time to leave, and I'm usually not even like this, but I know that you had more than enough time to leave because it said you're supposed to be gone on January 8th, 2026. Because when we had this hearing on November 18th, 2025, that's when you were supposed to be gone.
Correct.
Yeah, and so now we're on March 3rd, brother.
So what do you?
So I'm not going to have any more conversation.
The judge reviews the consent agreement and explains that the tenant had already agreed to vacate the property by January 8th, 2026 at 11:59 p.m. The landlord was also entitled to a writ of possession and a monetary judgment of $5,000. This was not a pay and stay situation, meaning the tenant could not simply pay money to remain in the property. The judge clarifies that the confusion occurred because of a clerical error in the original document where the year was incorrectly written as 2025 instead of 2026.
Because you low-key, it's kind of, I've explained it to you, I think, very well. So I'm either going to send you back with a mediator so it can be modified based upon what you made the motion for, or I'll let you go and I'll do it and make the update so that everything can proceed as it should. But we're not going to give you any more time, respectfully. All right. So you're either going to go back, give you the choice now. I'm going to give you about 5 seconds because I've got other people who need things done. And your case has been going on since November. So 1, 2, 3.
We can go back.
Okay. Thank you. Please, somebody go back with him. Don't waste my time, Mr. C. Now when you make the motion. I'll see you guys shortly. All right. Position 8, is that an impasse as well?
8's a consent.
Okay. Let me look for the consent. I do not have the agreement yet in my email. All right. All right. Well, I wait for that consent. Bear with me so I'm just waiting for it. Okay. And then I'll get you folks out of here. Now, Mr. Seeley, just bear with me. One of the mediators will be back in with you guys to get it done. You can go ahead and go on mute. And Mr. Williams and Mr. McKenzie, that was run back in November regarding a writ of possession and consent agreement, which is to confirm the following terms. The parties entered into a mediated consent agreement on November 18th, 2025. The following edits are agreed upon the November 18th agreement. Every reference to January 8th, 2025 in the November 18th agreement is hereby changed to January 8th, 2026. In the paragraph beginning, wherefore, November 18th agreement, the box indicating that the writ of possession will be issued on January 8th, 2025 at 11:59 p.m. is hereby checked. In the paragraph beginning, further agreed that in the November 18th agreement, the box indicating that plaintiff recovered the judgment against defendant is hereby checked. As a result, this confirms or corrects the original November 18th order. Are these the terms that you guys originally entered into? And was the intent to enter into back on your November 18th, 2025 agreement? Is that a yes, Mr. Seeley?
Yes.
All right, Mr. Sulowich, or Mr. Seeley?
Yes.
All right, Mr. Sulowich.
Yes.
All right, I'm going to sign it. You guys will get a copy of it in your email. Now, Mr. Seeley, as I said, I know the writ, I'm not sure if it was held, but, you know, how that gets to you, again, that has to be scheduled and dealt with. But folks, this should correct the issues. I'm going to email you guys a copy, and you guys will have a copy, and you make sure that
Mr. Seeley argues that the expired dates should give him more time to move out because he claims he did not have enough time earlier. However, the judge firmly rejects that argument. The judge points out that the tenant had known about the deadline since the original hearing on November 18th, 2025. Now it is already March, which means the tenant has had several months to prepare to leave. The judge becomes slightly frustrated and explains that the court will not grant additional time simply because of the clerical mistake.
Should keep the original, and this will correct that. Go from there.
And you said this is an amended consent agreement?
It's not amended. It just essentially corrects the issue with 2025. So it's not amended. So we're not really amending it, but it's just clearing it for Scrivener's error so that there's a correct clarity on what's going on. So this isn't a new agreement, but rather correcting the old agreement that had the wrong year date on it, date of year on it.
Okay.
All right. You guys are free to go.
Thank you.
Thank you.
In the end, the judge decides to correct the error in the consent agreement by officially updating every reference from January 8th, 2025 to January 8th, 2026. Both parties confirm that these were the original terms they agreed to. The judge signs the corrected order and explains that it is not a new agreement, but simply a correction of the previous document. With the issue resolved and the dates clarified, the judge informs both parties that they will receive copies by email and the case can proceed accordingly.